Okay, so enough of the general Division 6 issues. Now I want to turn to the streaming measures. We all know this legislation applied from last income year, and I've already made the point that it's likely to apply until at least the 2014 year. So I've got this year and the next year to come to terms with a lot of this legislation. It facilitates the streaming of capital gains and frank distributions if there is a power under the trust deed to stream those receipts. So a number of important things there. Streaming income or streaming is something we're all familiar with, the idea that we set aside or we allocate particular sources or classes of income for the benefit of the beneficiaries. The good news is this legislation allows you to do that in the case of capital gains and frank distributions, but importantly, you must have a streaming clause in the trust deed to be able to do that under trust law. So that's the good news. I guess it only covers those receipts, and there's still a lot of doubt as to whether or not you can stream other amounts. I think on balance at the moment we'd probably take the view that you can unless we're told otherwise. The other thing that I've found in working with this legislation quite a bit is that it's not limited to streaming. And I think this is a really important point that hopefully will be demonstrated in the case studies, that when you're dealing with any trust that has a frank distribution or a net capital gain, this legislation is an issue, even if it just has one of those. So you need to think about all the trusts across your practice. If they're deriving those receipts, then you've got to think about this legislation, whether you're streaming or not.